Good morning, everybody, and welcome to It's Time to Get Your You Know What Together. Here, we discuss everything from estate planning to how to avoid probate administration and everything else in between. So I'd love to introduce to you today Samantha Fitzgerald. Samantha is an attorney in plantation, and her firm is 100% focused on estate planning and probate and trust administration. She has been practicing for over 20 years. Pretty soon I'm gonna have to say 21 over. And she is a CPA, so she's got that math brain and has an LLM in tax. Everybody, let's welcome our speaker, Samantha Fitzgerald, please.
Thank you, everybody. Thanks, Bianca. Thanks, everybody, for joining us today. So today's presentation is prompted by all of the documents that we see in our office, oftentimes on the probate side, sometimes on the estate planning side, but mostly on the probate side, that are not signed properly. And I tell you, it's almost all of them. It is such a huge percentage, from the most obvious of somebody preparing their own will that they got on the internet or out of an Office Depot or something like that. You know, those we almost expect, are not going to be done properly. But even documents that are prepared clearly by lawyers that were signed in a lawyer's office, most of them are not notarized properly. It's really shocking that between the lawyer and the notary, they don't know how to properly fill out a notary block. So that was really the catapult to doing this seminar. So for whether somebody is signing a document on their own, hopefully they'll know how to issue spot. They'll know if something is amiss on the document, or for all those notaries out there who are notarizing documents, teaching them hopefully how to properly fill out a notary block. Anybody who's executing documents on their own. So, hopefully if you're executing documents with the lawyer, they're doing it properly. But as I said, that doesn't always happen. So hopefully somebody will get some benefit from this seminar.
Awesome. And you took the words right out of my mouth. So I just want to introduce myself. I'm Bianca Moreras. I'm your moderator and host for today. And we are going to be going through the nitty-gritty of exactly what Samantha talked to us about. Who would think notary is so important? So with that, Samantha, tell us, do all documents need to be notarized?
No. And so for today, we're talking about estate planning documents. So we're talking about wills and trusts and healthcare surrogates, living wills, durable powers of attorney, and deeds. Those are the primary documents that we do here in our office. And surprisingly, most of them don't need to be notarized to be valid. So the ones that are required to be notarized are deeds and durable powers of attorney. And that's technically it. Now, when executing a will, it's valid just with 2 witness signatures. And there's some requirements of how it gets signed. But then there's a second part to the will, which does require the notary. So I'm going to do a little screen sharing, and we can jump into that now. Let's see. Figure out how to. Okay.
Bottom middle.
I think I have to go to full screen mode first. Maybe.
No, just go.
Oh, share screen. There it is. Okay.
There you go.
Used to be at the top on mine. Now it's on the bottom. Okay. Nope, that's only giving me the option of, oh no, I'm sorry, I'm clicking the wrong button. Okay, here we go. Here we go. Next month we'll have a Zoom tutorial. Okay, does everybody see? I'm gonna switch now to the will. Does everybody see the will?
Yes. Can you maybe make your percentage bigger?
the document itself, let's see.
Yes.
It's pretty big.
There you go. There you go.
Yeah, is that
Perfect.
better? You want
Much
it bigger?
better. Yep, much better.
Is that good enough? Do you want it bigger?
No, that's perfect.
Okay. So this, so what we did was we made some signature pages only with the name of the document. So for instruction purposes. So this is the signature page of a will, obviously a fake person, Jane Smith. So in order for the will to be valid, Jane would sign right here. I don't know if you can you see my cursor moving?
Yes.
Okay, so Jane would sign right there. And then there'd be two witnesses in the same room as Jane, or at least within eyeshot. So this was an issue that came up during COVID that, you know, especially at the beginning of it when nobody knew what was going on, you know, some lawyers were bringing documents to clients' houses and maybe watching them sign through a window. We had to be very creative during COVID with these types of documents. You know, these documents were obviously very important during COVID. People were afraid of being incapacitated or dying. So we've been very busy, and we had to be very creative how we get these documents signed, because it requires so much. You know, it requires that we have lots of rules. We have witnesses and notaries, and you know, signing a will, you must be, and it says right in here, really, if you read it, and we're always big on read the actual document and it may answer your questions. So it says right here, and in the presence of two witnesses. So you must be able to see each other signing. So here's a witness here, and here's a witness here. So two witnesses are going to sign. So here's where constituents. So this is how a will is valid. Two witnesses, that's it. Will is valid. However, when the testator dies and they go to admit this will to the probate court, at that time, they're going to want one of the witnesses to go and testify that they actually saw this will get signed. Or there's a special procedure you can go through to get somebody appointed as a commissioner, and then that person can go take the oath of one of the witnesses. Well, that's really no fun when the will is 15 years old, 20 years old, and you're trying to track down a witness that could be anybody. So good luck with that. It's not so easy. So that here comes in the self-proving affidavit. So this part does get notarized, and this is why a lot of people think a will has to be notarized. So it doesn't actually have to be notarized to be valid, but it's best practice to notarize the will, but it gets done in a very specific way. And this is where we see most wills go wrong. Everybody's signature gets notarized, the testator, Jane, and both witnesses. So the notary cannot be a witness because they can't notarize their own signature. So you need 3 people in the presence of Jane Smith in order to make this will the best it can be. Self-proving, that's what we call this. So this is a self-proving affidavit. And then here's the notary block. So this is also where things go terribly wrong with notaries. Notary blocks come in all kinds of shapes and sizes. There's no specific way they have to be. And there's some new rules that have come into effect recently that have changed them, because now there's online notarization that's allowed. So you'll see now, we have right here, are you in the physical presence of the notary, or is this an online notarization? So this is new. This is very, very new. So in the will notary block, what's very important is to be clear that the notary has notarized all 3 signatures. It's not okay to say, yeah, I notarized this document and they were in my physical presence and I personally know them. You personally know who? Which one? The testator? The witnesses? Sometimes we see where they put, and driver's license was given to me and they put 1 driver's license number. Well, clearly that only belongs to 1 person. So what about the other 2? So that's the biggest thing we see with these, the will notary blocks, is that the notary is not notarizing all three signatures, or they're not identifying, that they notarized all three signatures. And then technically it's not a valid self-proving affidavit. And we're back to having to track down these witnesses or go through some special court process. So it's really, really important for notaries to read the notary block, fill in everything that's there on the notary block, because sometimes it's blank and we don't know. Sometimes we have to track them down and say, did you personally know this witness? Did you get some sort of identification? Because we can't just fill that in ourselves. There is a registry of notaries, so sometimes we can find them, which is nice. And if it was done recently, great. If it was done 10 years ago, they're probably not going to remember. So, this can be a huge problem, obviously, depending on the circumstances of the case and the beneficiaries and the friendliness of them, and whether there's any problems. So that's a will. So it requires 3 people to properly execute a will. Now, so another question we get, well, who can be a witness or a notary? Well, there's all sorts of rules with notaries. Notaries can't, notarize signatures of people they're related to and that sort of thing. The witnesses, they can be anybody. They can even be a beneficiary. It's not good practice to have a witness who's one of the beneficiaries in the will, but it's legal. So sometimes if you have no other choice, you can do that if you have to, but it's not good practice at all. So it's definitely not recommended, but yes, it is technically legal. There's really no requirements at all as to who the witness can be.
So, Sam, you talked about, the notarizing. So does a notary have to be at least 18 years old? Does a witness need to be at least 18 years old? What's that all about?
Yes, absolutely. So you're not legally able to contract or witness or do anything legal unless you're at least 18 years old, which is the age of majority in Florida.
Okay. So, and, you were saying that not all documents need to be notarized. Do all documents need to be witnessed?
Yes. So all and again, we're talking about estate planning documents. So a trust needs to be witnessed, a will needs to be witnessed, durable power of attorney needs to be witnessed, a healthcare surrogate and living will needs to be witnessed, and a deed needs to be witnessed. Everything needs to be witnessed, and they all need to be witnessed by 2 people.
Okay, so 2 people, and then the separate notary, which is showing us that, and it's amazing. I just learned something new about the online portion that was added. So that's incredible, and I'm always in the legal world. So can a notary also be a witness?
In the will, no, but in every other document, yes.
Okay, so that's good.
So because this is the will is the only document where the witness signatures also get notarized. So jumping over, it's a good time to jump over. Let's do a deed, because this is very common, Danielle. I'm sure you're very familiar with this.
Can I interrupt for 1 second?
Sure.
Going back to the self-proving affidavit, if you're having such a problem having the document, if someone chooses to do the self-proving affidavit, if you're having problems of the notary not filling that out properly, sometimes, when you see something like this, you get overwhelmed with all of the documents and the paper. If that notary has to notify the 3 witnesses or 2 witnesses, wouldn't it be beneficial, because obviously there's not enough room to put all of that's one of the concerns as a former notary of years back. Why don't we why doesn't the document have, add another paragraph?
What do you mean?
Well, okay, scroll to the self-proving document. Okay.
This part here.
It's the affidavit. I'm pointing to the screen like you can see me. But come down to the acknowledged and subscribed before me. Okay. So here, that notary, witness 1, Bianca. Okay, so it was a physical presence or who is personally known to me, has produced, and you put in Bianca's driver's license. Okay, and before me, each of the following witnesses. Okay, so you have that. Okay,
Yeah, it's there,
okay,
Linda.
so it is there. Okay, I'm sorry because I didn't see the other part.
Yeah,
All right.
that's our notary
Okay.
block.
Yeah.
You know, not all notary blocks look like that.
These words, and you know, when you're doing this, it can be a little bit intimidating, but yeah, I could see now it's better than what I have seen in the past.
And that's a great point, because as I said, they come in all shapes and sizes. You know, there's no required language. So I actually watched a whole seminar on notaries. It was put on by a lawyer, and he said, you know, we make it very clear in our notary blocks how to fill stuff out. And so we've adopted, you know, his advice and his suggestions. So if somebody actually goes through our notary blocks, and we have another one I should show you, I don't think we have it here today. This is what we use for our estate planning documents because it's a little bit different, but we have an even simpler one that we used on like an affidavit or something that we use, and it's very clear. You have to fill it in. It's very, very clear. There's no way to really mess it up. But my one big piece of advice to notaries, read the paragraph, because you will answer the questions if you just read the paragraph. And you know, and they all look different, you know, so it can be overwhelming. And even me as a lawyer, sometimes, you know, clients bring in documents and they say, oh, can you notarize this for me? And I have to take a second and I have to read through and see, where am I supposed to sign? Where are they supposed to sign? What do I need to check off? Because they're all so different. So people just need to slow down and read, but be aware that, like, because sometimes I've seen notary blocks on wills that don't even have places for the notary to say that they notarize the witness signatures. And that's where the notary needs to know, hey, I got to write this in someplace, you know, because this notary block is effectively deficient. So I need to add some language to it, which handwrite it in.
I know there have been times when it wasn't really clear to me and I wouldn't notarize the document.
Yeah, but it's better. I mean,
it just didn't make any sense. And they went, yeah, I said, well, I'm not signing it unless you make it where I can understand what you're saying. And sometimes, you know, we had like 10, 15 documents and it had to be changed on all of those documents.
Yeah, but that's good because
they realized it, you know, but it didn't make sense. And that's why looking at this was like, I saw all the words and I'm listening to you, but I'm glad to see that each line is, this one paragraph is for each witness. So I'm happy with that.
Yeah, good.
Thank you.
You're welcome. Let me go. Where's my mouse? It's not moving. Hold on. My connection is lost. Why? Okay, now. All right, I'm going to go to the deed and show you the difference. So here, we've got John Smith and Jane Smith signing, and we've got the witnesses. Well, this is a bad example. Apparently we didn't do this very well. So this notary block is prepared as if the witnesses are getting notarized as well, but that's not required in a deed at all. So normally it would be shortened. Let me show you a different one, which would be more like, so this is normally what a deed notary block would look like. So again, if the notary just reads it, it will tell them whose signature are they notarizing, and it's just the principal. It's just the grantor of the deed, John Smith. There's two witnesses, but only John's signature is getting notarized. Therefore, the notary can sign as a notary and the notary can sign as a witness. So they can sign twice because they're only notarizing John's signature. So you only need two people for a deed. which is very common in the real estate world.
Mhm.
So sometimes people who are used to doing those types of documents get confused, and they'll end up being a party to signing a will, and they'll do it wrong. I've even seen lawyers notarize their own signature on a will.
Wow. Wow.
Seen a lot.
So I have a question here in the box. What if I can sign my, what if I can't sign my name because I'm physically impaired? Is there any other way I can sign my estate planning documents?
Yes, this is where things get interesting. So there's several options here. So you can make a mark if you intend for it to be your signature. And a mark could be all sorts of things. It could be an X, it could be a fingerprint, any mark that you intend to be your signature can be your signature. You can also direct somebody else to sign your name for you. And then there's a provision for the notary signing on behalf of the testator as well. So there are several different things that you can do. You have to have your capacity, of course. You can't be incapacitated and somebody else sign your name. To some documents, that's okay if you have a durable power of attorney, but not a will. A will is not one of them that your power of attorney can sign for you.
Okay. So, I mean, we've heard so many things. Do you have any other documents that we should take a peek at that would help us out here?
So now we're going to look at the healthcare surrogate. This is where you appoint somebody to make medical decisions for you. This document doesn't need to be notarized at all. Now, in our office, we typically do notarize them because usually somebody's signing this with all their other documents, and it's just easier to notarize everything. So we do them all the same way. We have to have 3 people for the will anyway. So we have 3 people, we have 2 witnesses and 1 that's a notary. But sometimes if we're maybe just preparing a healthcare surrogate for someone, we don't want them to have to go through the trouble of getting it notarized if they might be signing it on their own, in which case it just requires 2 witnesses. The notary part is not needed, but if you do the notary can also be a witness because they're not notarizing the witness's signatures. And the one quirky thing about the healthcare surrogate is that at least one of the witnesses cannot be a blood relative, a spouse or blood relative.
That's funny because my next question was going to be, can a spouse be a witness? And could a spouse be a notary for that matter?
Not a notary, no, but they can be a witness. Yeah, in all of these documents, a spouse can be a witness. Now, again, it's not best practice. But sometimes, you're desperate, and especially during COVID, if you weren't able to go anywhere and you had limited resources of who can sign a document. So we never do it because especially if somebody's in our office, we have plenty of people, to witness, but they could be.
Well, it just dawned on me that my husband is really not a blood relative. So when you're talking about that, you're talking mother, father, child.
Spouse or blood relative, yeah.
Oh, so spouse or blood relative.
At least one. So the other one can be.
Okay.
I don't know why they do it with that document. And then there's the power of attorney. This is another one that must be notarized. So the rule is actually that the durable power of attorney, which is for financial decisions while you're alive. So if you're incapacitated, this gives somebody the authority to pay your bills and that sort of thing. The rule is that the durable power of attorney gets executed the same way a deed does. So they're identical, and oftentimes you see durable powers of attorney in real estate transactions. So they're very similar. And again, they both get witnessed, 2 people, and notarized, but the notary is not notarizing the witness's signature, so the notary can act as one of the witnesses. And it's important to note that when that happens, when the notary is a witness and a notary, they have to sign twice. They're wearing 2 hats. One is a witness, one is a notary. Sometimes we give these instructions to clients that are signing outside of our office, and we say that and we get it back, and then notary signed once. So we've had to make it very, very, very clear. They, just dumb it down. They sign 2 times.
Okay, can
Yes,
you
what
guys
else?
hear me? Because my internet is going in and out.
Yep, I can hear you. There's one more document, and that's the trust. So the trust doesn't have to be notarized at all, but we do them. So the rules say that any trust that has testamentary provisions, meaning that you're leaving something to somebody when you die, must be executed with the same formalities as the will. And going back to the will, that only requires 2 witnesses. That's it. The self-proving affidavit is really just a concept under the will rules. There's no such thing for the trust, but we do them anyway, just in case. We just execute it the same exact way. It's a big, long one. Same exact way as the will with the self-proving affidavit. It's very, very common. You see almost all lawyers prepare them the same way. I bet you half of them don't even realize that they don't actually require notarization, but they don't. 2 witnesses, that's it. Also, the witnesses could be beneficiaries, but not a good practice to do.
God, you would never think signing things would be so complicated because it sounds.
Yeah, and they're all a little different.
Yeah, that's amazing. So we have a few minutes left. So I really want to give Linda and Danielle, an opportunity to ask any questions that they have. Danielle, I see you unmuted.
Yeah, so I guess my question is, since it says personally known to me or an identification was provided, should that identification number be on the document? Because trying to track a witness that's just by name and signature, like you say, in a decade, may be impossible. But
Yeah,
it would be easier.
it's best practices, to put the actual identification number. The more identifying details you have of the person, the better. For us, when we're signing here in this office, we know everybody. We have record of every person that's signing, whether they're our client, they're our staff, so we don't have just random people. But when people are signing these documents on their own, it's very common that they pull in their neighbor, they pull in a friend, they go into the bank or a UPS store, something like that. You have no idea who these people are. So it's not required technically per the notary rules, but it is best practices to put the driver's license. And that's how we can identify, did they only notarize 1 signature, or did they mean they notarized all 3 signatures?
So like on the notary, on the address, like you write 300 North. Are you happy in your new office?
Love it.
You got a great view in the back.
Thank you.
So where it has your address, because like the witnesses, right? When it's not in your office, should they have their actual address that would tie into the driver's license number?
It would be best, yeah. And you're not even required to put addresses there. We put them in, but most of the documents don't require, witness just signs their name, and sometimes they scribble it and you can't even read their names. We've had so many wills, we don't even know who the witnesses are because you're not required to print it. Or sometimes they do print it and that's not legible either. So it can be very, very challenging, trying to find witnesses years later, even if you can read their name. They've moved, they've died. It's a mess.
I mean, the deeds I knew, because the attorney who closes the real estate always witnesses, and then I witnessed the second. So I know she's notarizing and witnessing. So that part I knew, but my takeaway from today is just bring it to you to get it signed. Like, this is just, I mean, the other stuff, all the other seminars, like, no problem. I followed, I could almost but this, I'm thinking, this is a basket of crabs. Just.
Yeah. We hate when clients sign the documents on their own. I mean, it doesn't happen that often, but sometimes it just has to, and boy, we have extensive instructions. We say, call us while you're in the middle of signing if there's any questions. We go over it with them, in advance. And it's gotten better because we've really honed in our instructional skills. But back in the day when we would send something and we would explain how to do it, it always came back wrong. Sometimes the signer of the document also witnessed. Sometimes they just leave those lines blank as if they're not important. We see all sorts of stuff. So when people are doing these documents on their own, they don't have a lawyer, they have no guidance. And, maybe they picked up a document online or from Susie Orman. Maybe the document itself is okay, but they don't know how to sign it properly. And therefore, you either have no document or it goes terribly wrong. And, you went to the trouble of trying to tie up your affairs and make things easy for your family, and you end up doing the exact opposite.
Yeah, I hear you. Linda, do you have any questions before we close the program? And you're on mute. I had put you on mute.
Okay. Personal property, Samantha, like antique furniture that belonged to grandma, let's say, or me, and jewelry. And I make a list who I want each piece of jewelry to go to. And is that incorporated into the will and gets notarized, witnessed and notarized at the same time? What's the best practice to handle that? I mean, I have a lot of nieces and nephews. I have about 13 and then about 7 great. So, which I'm not worried about them too much, but I want to know what the best way to do that. Is it a separate document that's, or should it be included in the will where I sign it and witnessed and notarized?
So that's a great question. It could be either way. So you can definitely include something like that in your will, or even better, your trust. The downside to that is if you make changes, you have to re-execute your document. So that can be very inconvenient. So you can have this, what we call a separate writing. And you'll see almost all wills refer to this separate writing. It's standard language, whether you have a separate writing or not, just standard language. But we also, because we do trust for almost all of our clients, we also do an assignment of your tangible items into your trust, so that technically all those things you just mentioned would be owned by your trust. And then we also make reference to this separate writing or memorandum in your trust. And then you can have this separate document that's super easy to change. It doesn't need to be witnessed or notarized. You just have to sign and date it. And that's it. So we always provide those to our clients because it's very easy to leave those things to anyone. You don't have to worry about witnesses or notaries, and you can change it whenever you want very easily. It can be on just a regular piece of paper. There's no formalities to it. Or oftentimes lawyers provide, the document to the client, but you can just use a regular piece of paper. So sign and date. That's the important part.
As we always say at the end of our program, first, let me thank Samantha. Wow, I learned so much myself. I'm going to put it in my little book. Okay. And I think all of us learned a lot that we couldn't even imagine just about notaries and witnesses. Oh my goodness. So thank you for bringing this program to us today. We look forward to every third Friday of the month to hear some glorious educational wise news from you, and we'll be back in October as well. And anybody that's on the call, as you know, from our fan club, Danielle, you can call the office and have a chat on any questions and a preliminary discussion, 15 minutes or so. And then we'd love to have you come to the office and see the new works and makings of a beautiful environment. So thank you so much, Samantha. You're just so wonderful. Thank you for being so smart as you are. And until next time, please remember, it's time to get your you-know-what together. So bye for now, everyone. And
thanks, Bianca. Thanks, everybody, for coming.
Thank you.